Welcome back to the Friday 5 for January 12th, 2024. Here in Minnesota, we're about to be hit with a real cold streak, but we're going to stay warm with 5 questions this week. Takes about 5 minutes to answer, FAQ style. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. So let's dive right into this week's 5 questions. Question number 1 this week, do I move my property into the LLC first, or do I move the LLC into a trust first? So in this case, the client was asking about a 2-step transaction. So he wants to set up an LLC and then move rental property into that LLC. He also wants to put that LLC into his trust. So these are 2 separate transactions, and his question was, do I have to do one before the other? And the simple answer on this one is you don't have to do one before the other. They're kind of independent of each other, so you can do them whenever you'd like. The LLC can be moved into the trust by either updating the trust or updating the LLC operating documents to evidence that the trust is now the owner. If you're going to do this, you want to make sure you've signed your trust agreement, that trust is in full effect. You're not doing the LLC before you've signed your trust. And the other step of moving the property into the LLC, this is a real estate transaction that's going to happen by filing a deed with the local property registrar. So it does not affect whether the trust owns the LLC or not, but we need to update the deed and get that filed, and that will move the property into the LLC. And if you're doing that, always remember to check with your lender first if there's a mortgage on the property, because if you're not careful and your mortgage has a due on sale clause, trying to move a property into an LLC may trigger your mortgage and you owe the full amount due when you try to make that transaction. Question 2 this week, where do I find articles of organization to fill out? This was a nice phone call I had with somebody who's out of state, not a state I practice in, but we were discussing how you get your company started. In this case, he was looking to do an LLC in a state down south, and he wasn't sure what the next steps were. So we discussed the importance of looking to your state's Department of State website. There's usually a corporations division. In this case, he was looking for the articles of organization form, which actually was available on the Secretary of State's website in a fillable PDF format. So that makes it pretty easy for you to fill it out yourself, because it really is basic information about your company's information, your registered agent, who the organizer is, and electronically signing it. What I told him is make sure once you've done the articles of organization, you make sure to loop back with an attorney and get that operating agreement put into effect and signed. Question 3 this week, do I need an accountant for my LLC? So another client had set up an LLC and things were going well so far, but they had a bunch of questions that really had nothing to do with the legal side of things. They were all accounting questions. They were wondering about whether they should take the S-Corp election. They were wondering about hiring employees. They were wondering about payroll. They were wondering about how they're going to pay themselves. All of these questions are great questions for an accountant. So you don't have to have an accountant to start an LLC. You can absolutely run an LLC without one. However, if you're not an accountant, if you don't have a lot of experience with tax laws and tax filings, an accountant can be your greatest friend and one of the biggest assets your business can have. It will save you time and it will cost you a little bit of money, but it will also likely save you money that you would have lost if you tried to do all these filings yourself and possibly did something wrong. Question 4 this week, if I've been sued, do I need to file an answer to the complaint? So you first have to look at the rules of the court you're in. So if you're in some small claims courts and some other very specific courts, you don't always have to file an answer. However, most courts, you do want to file an answer to the complaint that is filed against you. If you don't file an answer, the plaintiff or the other party who has sued you can take what's called a default judgment, which means they can go to the court and say, you did not answer the complaint, therefore I should win. Because they never answered, they're admitting my allegations and ask for a judgment for the amount that's asked for in the complaint. Now, this can obviously be a real pain for you if that judgment is for a lot of money, because then once they have that default judgment, they will then try to collect upon it, try to go after your assets, see what they can do to collect money. Now, if they're in another state than you have a little more leeway, because they then have to take that default judgment, transfer it to your state, register it there. There's a second proceeding. This is all to say that if you've been sued, you should file an answer in almost all cases. There may be situations where a default judgment's okay, but normally if you've been sued, you want to make sure you file an answer to preserve your rights and not get hit with a default judgment. Question number 5 this week, do I need a trust to avoid probate in Minnesota? Now, this conversation was interesting because the client had had meetings with other companies, not necessarily attorneys, but some of those online companies and other financial companies that were selling estate planning packages but weren't really doing the legal work. And what their recommendation was is everybody in Minnesota needs a trust. You have to have a trust to avoid probate. However, in this situation, the client didn't actually have a lot of assets that would require going through probate. And in fact, the main asset was going to be the house. And with adult children, the option they have is to use a transfer on death deed, which means that the property goes directly to the surviving individuals you designate when the two of you die, or whoever owned, if you're a single person, whenever you die. So in this case, to avoid probate, a trust wasn't necessarily needed because their bank account levels were low enough and the property could be put in a transfer on death deed, so that a trust wasn't going to actually add a lot to the probate avoidance part of their estate plan. Now, they had other issues that may actually end up in favor of creating a trust. There was a blended family. There were some adult children. We may have a child who seems to be having some special needs and may need employment or may need government benefits in the future. However, at this point, it wasn't necessarily sure that the trust was needed for probate, but maybe for other reasons. So those are our 5 questions this week. If you like this video, you can hit the thumbs up or the like button below. You can subscribe to future episodes on YouTube. You can always submit a question for future episodes in the link below. If you'd like more information about me or my law firm, you can go to 𝙃𝙀𝙍𝙊𝙒.com. We could set up a legal strategy session to discuss your questions and give you some next steps going forward. Wherever you are, I hope you have a wonderful weekend. And if you're in one of those states that's about to be hit with a snowstorm or some cold, I hope you stay warm and dry.